our exhibits show, and there are people on the Zoom hearing today who would testify that Mom has a long history of putting her hands on children in her home, of physical abuse, of belittling children in her home for their gender orientation or their sexual orientation, for putting her hands on people when she gets upset, for throwing things at kids, for locking kids in their rooms, for encouraging kids to take medication, for putting children on medication that is not prescribed to them based on her ability to prescribe as a medical practitioner. These are all things that have come to light in the last couple of months and are only in support of this idea that there needs to be an additional investigation here. Something is going on in this home. Something is going on in the state of Oregon that these parents have not been privy to. And we don't feel it's safe to just insert a child who has expressed all of these concerns, who has made it clear to her therapy provider, who has been diagnosed with PTSD, to simply place her back in this home for 8 weeks without the court speaking to her to gauge what her perspective is. And she's 16. She can give her position. And doing a deeper dive into what is actually going on to understand whether this home is safe for her to return to ever. A child should not be forced to face her abuser and be put back in that situation. And we believe that's exactly what would happen here. So we are requesting that the court just push pause on Mom's parenting time until some of these things can be investigated, can be made known. I haven't been able to get a hold of the forensic interview that occurred at Sunlight Children's Home or do a DCF subpoena that would allow the court to review the DCF records and their investigation. And I think all of those things are prudent before the child is shipped to another state for an 8-week period under these circumstances.
So this DCF investigation was initiated when?
I think there have been several DCF investigations, is my understanding. When the child went to Sunlight Children's Home for therapy, my understanding is that she made statements to her therapist that resulted in them doing a forensic interview. And then DCF reports are anonymous, but my impression is that things were addressed that were then reported to DCF. However, DCF's position has been that they will not release the forensic interview or those records without a formal subpoena and then, as all the attorneys know on the case, those records are then submitted to the court for in-camera interview and are only released under a protective order once the court has reviewed them.
So this is Kansas DCF investigation that's been initiated here since February?
Guys, the first real battle here isn't over parenting time. It's over what information the judge should even consider. One side wants the court focused tightly on what changed after the February agreement. The other argues that older history matters because newer concerns supposedly give that history fresh relevance.
Yes, Your Honor.
I believe it's unsubstantiated, Your Honor. If you look at one of our exhibits.
Okay. Is there any coordination between Kansas DCF and the Oregon equivalent in this investigation?
I think those are things that would come to light when we got the DCF records. But again, timing-wise, I was not able to complete that business record subpoena prior to our hearing today.
All right. Anything further, Ms. Locke?
No, Judge. Again, I would stand for questions and just reiterate our request that the minor child have an opportunity to share her position with the court.
Okay. I may have some questions. I'd like to hear Mr. O'Hara's response at this time.
Yes, Your Honor. I'm relatively new to this, but this is very concerning. It appears to be complete parent alienation. It started, I don't know when it started. They filed an emergency motion back in December to not have the child go back. They decided to do that. They filed a motion for the child to be interviewed. And then my client, trying to be a good co-parent, agrees to a February settlement that they agreed to and was signed by the court that specifically said that the child would come back for summer for 8 weeks. Everyone knew that in February. All these facts that are alleged are old. What they put in is they allege all these things and come up with this complete alienation. I think Your Honor ought to really look, because they didn't send the child to be interviewed by Sunlight until April. It appears from the report that I see. And so they get her in April, right before she's supposed to come back in May. And now they've got all these concerns that we need to do a quote deep dive, whatever that is. And it's just complete parent annihilation. They're trying to prevent my client from seeing her child. And they're trying to let the child control what goes on. And I guess what gets me, Your Honor, is it would seem as attorneys, when we settle something in February, and now May comes, and the agreement for Mr. LaRue is he specifically agreed that she would come back for summer, knowing these things that have been alleged, knowing all those things, and he intentionally doesn't allow his child to come back. And Your Honor, what parenting is about is that for anyone that has children, is sometimes the children won't want to do things. And sometimes we must make them do things as parents to be responsible. And that's how we do things. I myself as an attorney, sometimes I don't want to do things, but when Your Honor or another judge orders me to do things, I do things. Mr. LaRue agreed that his child would come back to Oregon on the last week of May of 2025, and he agreed to that in an order that was filed on February 24 of 2026. And now we're in early June, and what he's done is He sent his daughter, as I understand it, to be evaluated and looked at, and now we have this deep dive that they want to do. And even though he filed a motion before he settled this for his child to be interviewed by you, and he agreed to not have that done, and he agreed to go by this order, now he files a motion again. And here we are again, because what he wants to do is his child says she doesn't want to go back, and parents can manipulate children all they want. But this child is in control of this case, and neither is Mr. LaRue. And when your honor makes orders, they're supposed to follow those. My client purchased a ticket. We sent the ticket to opposing counsel, and the child didn't get on the plane. And that's what happened in this case. And then comes the emergency order. And then comes this, that we've sent her, that now she's in a safe place, and we've sent her to a safe place. Your honor, the arguments don't even make sense at times. They say there's no interaction, but limited interaction. My client tries to interact with her daughter. And if they really want there to be interaction, it seems they would have sent her back. That her brother is with my client right now, and there wants to be a relationship between the sister and the brother, but they don't send my client the child back.
How old is the brother?
I'll have to ask my client for sure. Ms. Cortez, can you tell me?
He's 11.
Thank you. You go ahead and he's 11, Your Honor. He's at home. They make all these allegations about what has happened, all these old things. My client is a nurse practitioner. She's going to try to do everything she can. There's been all these allegations made, and we've attached the facts that they've all been unsubstantiated as they continue to manipulate this situation. And I suppose we get to a point sometime in life where if the manipulation gets too bad by a parent, and the parent keeps doing it, like Mr. LaRue appears to be doing it, that it ruins the relationship with the kid. And that appears to be what's happening here. But it seems to me, Your Honor, that order was made in late February, and nothing material has happened different since then. And that child ought to be ordered to go back. And if they're worried about the cruise, my client was going to put the child on the cruise with her, but now, I don't know, we can make it for the 12th, if that's what they want, Your Honor. But the child ought to go back, as agreed in February. There is no emergency. There's no reason for the child to be interviewed. When you read this report that they do from the therapist, I don't even know if they could talk to my client about going and taking the child to a therapist, which they agreed they would do, but I think in their agreement, but they go ahead and do it. It's only the child's interest in there. It's nobody else's interest, and the interview is all with the child. And it's just letting the child control everything, Your Honor. And if the child is going to learn that they can manipulate themselves around court orders by their dad enabling them, well, then we're not ever going to get anywhere with this child. And my client is even concerned. My client understands that the agreement on specifically was done in February, that the child was supposed to be attending school in person, and it turned to virtual school. And despite the allegations, we understand there were F's made. There may have been an F made in court. So I don't know that everything's going quite as rosy as they make it to go. But it seems to me, once the parties agreed, they had to stay with the agreement. And if problems arise in Oregon, Your Honor can address those. We can all address those. But the agreement was made, and we need to follow it. And I think it's very concerning that the counsel and her client aren't following the order that they agreed to in late February.
Mr. O'Hara, you indicated that the DCF reports were unsubstantiated. Is that part of some of these exhibits?
Well, my first exhibit, Your Honor, I think, is from Notice of Kansas Department of Findings, and it says a name of alleged victim, Bree LaRue, and it says emotional abuse, unsubstantiated. Bree LaRue, physical abuse, unsubstantiated. The date of mailing is 4/15 of 2026. Now, I don't know whether they're making more allegations since. It just goes on and on. It doesn't seem to end. I don't know whether they've made more. My client doesn't have any notice of that.
The father's side has to transform concern into something legally meaningful enough to justify interrupting an existing parenting schedule. The strongest part of that presentation isn't simply that the teenager doesn't want to return. Courts hear resistance from teenagers in custody cases all the time.
She also attached something from Colorado where there were some kind of concerns. Those have been dismissed. I found from someone was reported in Oregon, evidently, as this keeps going on, she can't get the paperwork, but as Your Honor can see, the email that she got from that DCF there says unfounded for physical abuse. It just goes on, Your Honor. And as far as the divorce with the other person that they have here, that's an ongoing divorce. And we attached an order from the court that my client is able to have her visitation and custody with the children, and so is her husband that's going through the divorce, but that's a separate matter. This child ought to follow the agreement that they made in late February.
So there's not a pending PFA type proceeding in Oregon?
Well, Your Honor, not that I know of. I can ask my client if Your Honor will allow me. Ms. Cortez, is there anything pending PFA wise or anything like that?
No.
Okay, go ahead and mute.
All right, I need a clarification. Ms. Locke, in your proffer, you indicated this DCF investigation. Is that the one that would be reflected in these unsubstantiated findings?
Your Honor, again, without the business record subpoena, I don't know that for certain. This was the first time I've seen an unsubstantiated document. My client has not received a copy of that. So I didn't know the status, and the DCF investigator wouldn't speak with me. She would speak through Sunlight without the business record request.
Mr. O'Hara, what about the new man or boyfriend or whoever is residing in the residence? Is that accurate?
My understanding is there is a new man in the residence yard. I don't think there's any problems with that. I don't think that's prohibited by anything.
Okay, there's oftentimes in custody orders, there's language that requires the other party to be notified or provide information regarding that individual. I mean, was any of that done here?
Well, you know, I didn't do that original. When I was looking through it, I didn't see that. But I mean, there was a lot of things in there that I was going to say about what happened. But I don't see that in there. I think they probably should have notified my client when they took her daughter to therapy, but I guess I wasn't done either.
When is this cruise supposed to take place?
I believe it's one of their attachments. I think it ends June 11, Your Honor.
It ends June 11th?
Yeah, June 11. I think they were going to take it. And they were going to add. I had discussions with my client, and she said she was going to add her as soon as she got there, if she ever got there, and she didn't.
When is it supposed to start?
Just a moment, Your Honor.
The itinerary shows June 7th, Jench.
I think that's right. That's why, in light of what's happened, Your Honor, I think the client, the child coming June 12th would be appropriate at this stage.
I don't typically review the exhibits unless they've been stipulated to or admitted. So where can I find this itinerary?
Exhibit H, Your Honor.
In Ms. Locke, your exhibits?
Yes. Lots of exhibits, Your Honor. I can ask my client, Your Honor, if Your Honor would allow me. Ms. Cortez, what's the day of the cruise?
The cruise starts on June 7th and ends on June 11th.
Okay, you can mute.
Okay. Now, Mr. O'Hara, there's an allegation here that your client's not letting Bria visit with her brother.
My understanding is that's what was said orally here. I don't know that I have talked to her about that. I think she wants her brother to come there to Oregon so that they can live in the same home. So I assume that they will speak when they're in the home. I think that allegation was they weren't speaking on the phone or texting each other. As I understood, I think that's the brother that's going to be in the house, Your Honor. In Oregon, the 11-year-old.
Who all lives in her home?
My understanding is the 11-year-old is there, at least at the present time. And I think there's the boyfriend that's there. I don't know that anyone else is there presently. Ms. Cortez, can you confirm that?
Yes, the 11-year-old Brantley is there. My boyfriend comes back and forth between here and California, and then I have my 4-year-old twins.
So she has 2 other children there, Your Honor.
So the boyfriend comes back and forth from California and lives there sporadically?
I've not discussed the status of the boyfriend, but my understanding is he comes back. He does live there part-time, Your Honor. I don't know if there's any allegation he's done anything wrong. I don't know what the problem is.
All right. Well, generally, the court has concerns if an unknown male or whoever going to be residing in the same home as a 15-year-old daughter causes some concerns, and typically the identity of that person should be made known to the other party.
Your Honor, I think that's a concern. We can have a boyfriend not reside there. We'll agree to that.
All right. Ms. Locke, I'll give you an opportunity to provide any rebuttal if you wish.
Thank you, Your Honor. Let's talk first about the cruise. So you have this child who's residing with mom as part of his summer time. And that case is out of Sedgwick County. He's sending via...
The mother's attorney has a clean procedural argument. The parties made an agreement, the summer schedule was known, and many accusations allegedly predate that deal.
Via another phone that he has to hide from his mom, messages to the daughter involved in this case about the cruise. This is occurring before the plane ticket was even purchased for her to go back to Oregon. So she knows while she's in Kansas that they're going to go on a cruise and that she's not on the itinerary. So that just kind of sets the stage for the environment that she's expected to go back to. Mr. O'Hara,
he was providing this information to Bria?
correct.
Who was?
The minor child, the 11-year-old. He I shouldn't even say that because I don't want him to get in trouble, but he has an old phone that he can connect to Wi-Fi to communicate with Bria. So he has communicated with her in secret from his mom.
So the concern was that she was going to fly out for her 8-week visit in Oregon and then be left out of the cruise?
Correct. We left at home with we don't know who, while mom, boyfriend, and brother went on this cruise to Mexico. Your Honor, the plane ticket that Mr. O'Hara sent to me was for May 24th. Today is June 3rd. We filed this motion. Mr. O'Hara and his client have done nothing to enforce the prior order. There was nothing done to attempt to enforce the child getting on the airplane. There was nothing done to try to have an emergency filing to say she has to go or dad needs to pay for the plane ticket. I mean, nothing has come of this. And my client has taken an affirmative step to say there's something wrong here. And I appreciate that Mr. O'Hara thinks that we have these duties and obligations. We do, but the court also has a duty and obligation to the child in this case. And she is screaming for help. She's asked her therapist. She's talked to her dad, who she now has a comfortable relationship with. And she asked previously to speak with the court. The parties reached agreements. Now she's more comfortable with her dad, and she is renewing that request that prior to going to be with mom, she wants to talk to the court. It's difficult to ignore a minor child that is making these statements over and over. Now, if the court says she has to go, then the parents obviously will try to make that happen. But you're not talking about an infant that just gets on a plane with another parent. You're talking about a full-grown female that has said, I will run away. I'm refusing to get on that plane. I will harm myself if someone makes me get on that plane. And those are red flags that are concerning. And I think they warrant at least a conversation and looking at the issue. We do have concerns about what goes on in mom's home. We have genuine concerns that have come to light since the agreed order. And we hope that the court will take those things seriously and consider the other individuals that are on the hearing today and the statements that they have made that we have provided as exhibits.
All right. Thank you, Ms. Locke. I think I would want to visit with Bria, and I'm going to do that in a private breakout room at this time. So Angela, if you could set up the breakout room, but I didn't intend to have her brought back into the hearing.
Okay, if she comes back on, I'll just leave her in the waiting.
Okay. She's at the Sunlight Children's Facility. Okay.
Advocacy Center.
Advocacy Center. All right, we'll go back on the record. Let the record reflect the appearance of the parties and counsel. I've had an opportunity to visit now with Bria in the breakout room. Had a nice conversation with Bria. Taking into consideration now my history with the case and hearing the statements that have been made, reviewing some of the documents, it's always concerning when you've got a 15-year-old going through these types of issues. Divorce is never easy on kids, especially when they reach that age. As has been known here, these parties reached an agreement in February on this custody plan. The issue the court is to decide today is whether or not to suspend the mother's parenting time that was to have started already at this point due to concerns that have been raised by dad. And some of these have been ongoing. But in visiting with Bria, I kind of got a better understanding of what she's going through. And I think the issues give the court less concern about her physical safety and any sort of mental abuse. I think she just wants to be acknowledged and loved in her mother's home. I think she feels that she doesn't get that. But I don't think it's I feel it's necessary to suspend mother's parenting time, but I do think some modifications and some parameters need to be done to make it happen. And
The judge shifts attention away from broad accusations and toward details that can actually be tested today. The new boyfriend becomes important not because having a relationship is automatically improper, but because an unfamiliar adult may be sharing a home with a teenage girl during extended parenting time.
some of these concerns that are going to be addressed may no longer be concerns. It's my understanding that Bria was living there through December and then came back here, as we all know. But one thing I want to make sure is that she has her own room. Is that something that's possible in the home that,
Bria has always had her own room.
Just
Yes.
answer the judge's question. Is that possible? Yeah. Yes
Yeah.
or no? Yes. She will provide her own room, Your Honor.
all right, to have her own room. I don't want her to be given the responsibility of babysitting the other kids the whole time that she's there. I don't think that that's appropriate for her to do. I think she'd like to spend some time with her siblings, but she doesn't want to be felt like she's the one that has to take care of them all summer. What's the setup? And I can address you, Mr. O'Hare, I can ask your client directly. It's probably easiest if I just ask her directly.
Yeah, I'm sorry, Your Honor, I do not know the answer to that question, so you may want to talk to my client.
Can I just address her directly?
Yes, Your Honor.
All right. Ms. Cortez, do you work?
I do, yes.
Okay. What hours do you work?
I generally work Tuesday through Saturday it kind of varies, but generally about 10 to 5.
Who watches the kids while you're at work?
They go to New Horizons daycare during the week, and then on Saturdays I have a nanny that watches them.
Okay. So they have somewhere to go where Bria is not going to be responsible for looking after them while you're at work.
Yes, Your Honor.
All right, and she will have her own room.
Yes, Your Honor.
Okay, well, those are a couple of concerns. I want her to be able to communicate with her therapist. I believe her name is Megan. She does that weekly. I'm assuming that's probably in person, but arrangements would need to be made for her to hopefully be made that she can continue speaking with Megan weekly by phone while she's in Oregon. Is there any reason why that wouldn't be able to happen?
Well, Your Honor, it will happen.
We agree to that, Your Honor. We'll do that.
Judge,
I
could
wanna-
that be by telehealth if it is available, other than phone call, like a video call?
Oh, I think that'd be, if it's technologically possible, I think people prefer that.
And Your Honor, that's fine. Video's fine. Whatever the therapist requires, Your Honor, we'll agree to.
I want to make sure that she's got use of her phone and can be able to contact her dad while she's there. I believe the order that was agreed to in February contemplates the visits with parents by phone. Let's look at that. Phone calls. The non-custodial parent will have access to a mobile device for the minor child. The non-custodial parent will not monopolize the child's time, but may communicate with the minor child at her leisure. The minor child will not be restricted from communicating with her siblings. So I want her to be able to visit with her dad. Now, that doesn't mean I want her on the phone talking to her dad 4 or 5 hours a day or something like that. But I think she feels that sometimes the contact with her dad is being monitored, and I don't want that to be happening. All right, those address a lot of the concerns that I think will make her time in Oregon more enjoyable. I think she'd like to spend quality time with mom doing fun activities rather than just being there and while mom goes off and does other stuff. I think Ms. Cortez, this is going to be a good issue or a good time for you to reestablish.
The rebuttal sharpens the father's position because it connects several separate concerns into one emotional picture. The hidden phone, the cruise information, the failed flight, therapy, and the teenager's resistance are presented as signs that this isn't ordinary reluctance about summer visitation.
Connection with her that seems to be fractured. So those are concerns that I had. I think the time, I don't want to send her out there until after this cruise is done. I'm going to task the parents to set that up in the manner that they've been doing. If who paid for the ticket that had to been canceled? Was I able to get a refund on that?
Your Honor, my client paid for it. I don't know whether she is able to get a refund. Mr. Cortez, can you answer that?
I was unable to get a refund.
I'm going to ask that Mr. LaRue pay for the new flight.
Your Honor, can we get proof of payment of the original flight?
I think that's appropriate. I want the name. I'm concerned with the boyfriend in the home. I'm going to order that he not be allowed to reside there during Bria's parenting time this summer. If he's going to be around her, Miss Cortez needs to provide his name to Mr. LaRue. If there's issues that are arising with the mental health of Bria that aren't being adequately addressed through her weekly, whether it's telehealth or telephone contact with the therapist, Miss Cortez, I ask that you try to set up something locally that would assist her and make sure that Mr. LaRue is notified of any serious issues that would lead to hospitalization or otherwise. All right, I think that kind of addresses concerns that I had in this visit going forward. Counsel, Ms. Locke, is there any clarification that you need?
Judge, my understanding is that this visit will start after the cruise, presumably the next available date that they can get a plane ticket, and it will just continue to the prior ordered time. Is that correct?
Correct. I believe the order simply states 8 weeks starting at the end of May. So we'll just presume if it starts July 12th or whenever, 8 weeks after that.
After speaking privately with Bria, the judge separates two questions that had been bundled together: whether she faces the level of danger alleged, and whether she feels emotionally secure and valued in her mother's home. Those aren't the same issue.
That is likely going to run into the beginning of school. So I'll see if the parties can talk to each other about resolving that.
Okay, I don't want her to have to miss school. If the 8 weeks has to be cut short a few days, then that's what's going to need to happen.
And Your Honor, I think the parties should be able to coordinate when school starts, and then we'll make sure she's back before that.
Okay. That will be the order of the court.
And then regarding payment, if mom is not able to provide proof of payment and that she wasn't reimbursed for any payment, if she doesn't provide that, does Mr. LaRue still need to purchase the ticket, or will the prior plan for payment be in place?
And Ms. Cortez, you can provide that proof?
Go
Yes, I
ahead.
can.
All right. Absent being able to provide the proof, then Ms. Cortez would need to pay for the plane ticket. Does that answer your question, Ms. Locke?
Yes, Your Honor.
Okay.
And I just want to clarify, there was a statement made by Mr. O'Hara during his argument that the parties did not agree for the child to go to online school. That's inconsistent with the order. She was enrolled online for the remainder of this school year and will go in person starting next school year and will remain in person unless otherwise agreed by the parents. So it is the intention that she will be enrolled in Flint Hills schools and remain at Flint Hills schools unless the parents agree otherwise.
And that's in person, correct?
Correct. But otherwise, I don't have any questions, and I will prepare the order unless Mr. O'Hara has other clarifications.
Okay. Mr. O'Hara, any clarifications on your end?
I do not, Your Honor. You've been very clear. Thank you very much.
All right. I hope you all can make this work for Bria's sake. She's a good kid, and I want her to have a good summer. So let's try to make that happen to the best of your abilities.
Thank you, Judge.
All right. We'll be in recess. Thank you, everyone.
Thank you, Your Honor.
Now the judge gets extremely practical, and that's revealing. Work hours, daycare, a nanny, therapy access, phone use, and private communication with dad become the center of the hearing. These details may sound less dramatic than the earlier accusations, but they're exactly where a workable custody arrangement succeeds or collapses. The court is effectively removing predictable pressure points one at a time. Bria shouldn't become default childcare. Her therapy shouldn't disappear because she crosses state lines. Contact with her father shouldn't feel monitored. At the same time, the judge puts a boundary around that contact so it doesn't consume the visit. That balance matters. The goal isn't to let one household dominate the other from hundreds of miles away. It's to give this teenager enough stability to spend real time with her mother while preserving the support system she already relies on. The court is now converting concern into enforceable structure. Delaying travel until after the cruise removes one obvious source of tension before Bria arrives. Requiring proof concerning the lost ticket addresses accountability without casually assigning financial responsibility. Then the boyfriend issue becomes much more concrete. His identity must be provided, and he isn't to reside in the home during the summer parenting period. That's a significant example of how judges can respond to uncertainty without making a finding that someone actually did something wrong. The mental health instructions follow the same logic. Weekly therapy remains part of the safety net. Local assistance should be arranged if needed, and serious developments must be communicated to the father. None of that treats ordinary family friction like an emergency. It creates safeguards around the areas the hearing exposed as vulnerable. The fight has shifted from competing accusations to measurable responsibilities. The final stretch shows why precision matters after an emotionally charged custody hearing. Once the larger dispute is addressed, the attorneys start cleaning up the mechanics: when the visit begins, how long it lasts, whether it can interfere with school, who purchases the replacement flight, and what proof is required. These details aren't housekeeping. Ambiguous orders create the next argument. The school clarification is especially important because counsel had challenged the online arrangement, while the existing order apparently reflected something different. Correcting that on the record prevents a disputed narrative from quietly becoming accepted fact. The judge also refuses to let the 8-week concept override the child's return to school. By this point, the courtroom's focus is no longer on who delivered the strongest accusation, it's on whether both parents can follow a detailed structure designed around Bria's summer, education, communication, and stability.